Good morning, America. Good afternoon, Europe. It's an honor for me to introduce my colleagues. First, Cecilia Villanueva is a part of my law firm and international matters. And say hello.
Hi.
And Marc MICELI is a colleague from United States. Hello, Marc.
Hello.
And Raffaele RIZZI, he's a colleague from Italy. Good morning, Raffaele.
Hi to everybody.
Okay. My name is Rubén Acosta. I am the president of the Bankruptcy Law Commission of the International Association of Lawyers. The theme of this day is the means to deal with the insolvency in the post-COVID-19 era. You know, we have a new situation in the world, new economic situation. The companies all over the world have a lot of financial problems. There is a lot of people losing their jobs in every country. And I think it's a very great opportunity to the lawyers of the world to take care of these situations. And that's why today we are going to see the situation in the United States by Marc MICELI, then the situation in Italy by Raffaele RIZZI, and if we have time, we can see the Mexico situation presented by me. Let me introduce Marc MICELI. First, his resume.
Marc MICELI is an attorney with the law firm of SM Law PC, a boutique insolvency law firm in Oldwick, New Jersey. Marc's practice focuses on all areas of insolvency law, bankruptcy law, creditor rights, and state court insolvencies, suits such as assignment for the benefit of creditors proceedings and receiverships. Marc is a member of the UIA as well as a member of the UIA's Bankruptcy Commission.
All right, let's go, Marc.
So good morning, everyone. So let me get to the first slide. So what's going on in the United States? We had shut down basically everything for the last couple of months. New Jersey is slowly reopening along with the rest of the country. But we anticipate that there's going to be a lot of bankruptcy filings coming down the pipeline probably the next 6 months due to the coronavirus. So I'd like to start by talking about federal bankruptcy law, because that's going to be something that it will be a candidate for businesses trying to reorganize or liquidate. So I'll start with, there's 6 primary chapters of bankruptcy under the federal bankruptcy law. There's a chapter 11, which is typically used by businesses to reorganize. It could also be used by a high net worth individual that needs to reorganize. The chapter 7 bankruptcy is the typical bankruptcy for individuals with no assets. That's your typical liquidation. Businesses can also use it to liquidate their assets. There's a chapter 13, which is the individual reorganization. That's for people that want to keep their house and they make money, they're salary earners, and they could file a chapter 13, which is a very narrow type of reorganization. And then you have some other chapters that are a little bit more unique and exotic. Chapter 9, which is a municipal bankruptcy case. You probably heard of those with Puerto Rico. Chapter 12 are for family farmers. And then you have a chapter 15, which is a United States' recognition of an overseas bankruptcy proceeding. And there's one subchapter that I'd like to talk. I'm going to spend a little bit more time on with the panel because it just became effective in February 2020. It's called subchapter 5. It's specifically designed for small businesses, and we're very excited about it. So before I get into the different chapters, let me just talk briefly about the main primary features of a federal bankruptcy case. The very first thing that happens when a bankruptcy case is filed is that there's a concept called the automatic stay. The automatic stay basically stops any creditors from continuation or commencement of legal proceedings against the debtor or the debtor's assets. There are exclusions from the automatic stay. For example, if there's a criminal matter that's moving forward against the debtor, those will typically move forward irrespective of the automatic stay. Domestic relations issues like spousal support, child support, those type of things can move forward even with the bankruptcy filing. And then, of course, the state police powers, for example, taxes or things like that can move typically without the necessity of doing anything with the automatic stay. But the automatic stay, for all intents and purposes, stops creditors from seeking to recover assets from the debtor or the estate. There was a new act that was put in 2005. Just want to mention it briefly, that the automatic stay, if you have more than one filing in a year, for example, if you file a bankruptcy and it's dismissed and the debtor refiles the bankruptcy case, the automatic stay is only good for 30 days. The debtor actually has to ask to have that extended beyond 30 days. If there's more than 2 bankruptcy filings within a year, then there's no automatic stay, but so the debtor really has to request that from the outset to have the automatic stay in place. Of course, creditors can also move and file a motion with the court to lift the automatic stay for cause or lack of adequate protection, which means that there's not enough equity in the property or they're not otherwise paying their taxes. The second big component of a bankruptcy is it allows a debtor, particularly a debtor in a Chapter 11 reorganization, to assume and reject contracts. I imagine that this is going to be something that you're going to be seeing a lot of. Retail bankruptcies are on the rise. Of course, retail was in a lot of trouble even before COVID. But I think with COVID and the shutting down of the shopping malls is going to accelerate a lot of the problems that retail was facing even before COVID. So what the debtor can do in a Chapter 11 is basically assume leases with, let's say, shopping malls that are performing well, but it also gives them the right to also reject certain leases or executory contracts that are not performing so well. Of course, there's as far as an assumption, you have to pay back what you owe and provide adequate assurance of future performance when you assume a contract. But rejection is something that's typically granted if a debtor asks for it. And in commercial leases, just to add a point to it, commercial leases are automatically rejected if they're not actually assumed within 120 days of a bankruptcy filing. And the last concept I just want to mention quickly is the debtor discharge. So at the end of a case, a debtor, whether it's an individual that files a Chapter 7 or a business that consummates a Chapter 11 plan, will get what they call a debtor discharge. And that basically means that they don't have a legal obligation to pay back their loan after the bankruptcy case is finished. There's some exceptions to discharge. They typically relate to individuals. The exceptions are for fraud, defalcation, larceny, taxes. So if there's any of those items, a debtor may not be able to get the discharge. So I'm going to speak very quickly about the Chapter 11, a traditional Chapter 11 case, only because it's going to provide a little bit of framework for the very brand new section that we have in the Bankruptcy Code. So like every other bankruptcy case, debtor files a petition and bankruptcy schedules, which lists all the assets and liabilities of the entity. It also discloses any transfers that were made within a year or two, and it provides other information about the debtor's business. Where the debtor files is important. It is usually filed where the debtor's principal place of business is, or where their assets were within 180 days prior to the bankruptcy proceeding. Once a petition is filed, a 341 hearing is scheduled. Basically, a 341 hearing is what they call the first meeting of creditors. In most cases, it's just an interview with the trustee, whether it be a Chapter 7 panel trustee or the actual U.S. trustee in the Chapter 11 case. And they basically ask questions about the debtor's finances, assets, and liabilities, and what the debtor plans to do going forward. In the Chapter 11 case, I should also note that a committee of unsecured creditors can also be appointed. They usually are comprised of 7 of the largest unsecured creditors, They can take an active role in a bankruptcy case by either investigating the debtor's financial affairs or actually assisting in the formation of the Chapter 11 plan. Committees can also retain their own professionals, which adds an additional cost to the case. I'm going to speak very briefly about administration. Once a case is filed, usually debtor cases are filed under emergency situations. When you file a bankruptcy case, basically a new estate is created. The debtor needs permission to do certain things. So they need permission to retain their professionals. They need permission to use cash from the bank accounts. They need permission to keep utilities on, and etc. So those are usually done by motion. They're called first state papers. And that's usually the very first thing that happens in a case. Once those are done and the hemorrhaging of the cash is subsided and the debtor gets some footing, then it's on to the disclosure and plan process. And that's really where the debtor is going to make its proposal and how it's going to pay creditors in the bankruptcy case. In the traditional Chapter 11 case, there's a concept called the exclusivity period. That allows a debtor to be the only party in interest that can file a plan up to 120 days after it files the petition. After that date, unless it gets an extension, any party in interest, a creditors committee, a secure creditor can file a competing plan, and that could cause some issues for the debtor because now you're having competing plans in the case, and obviously every plan is going to be written from the standpoint of the party that's proposing it. Obviously, those dates can be extended by a motion of the debtor. Let me speak briefly about the disclosure statement. The disclosure statement is basically like the prospectus that you would find from a company soliciting shareholders. It basically has to set forth adequate information. That's a term of art under the bankruptcy code. It has to tell creditors and interested parties what caused the debtor to go into bankruptcy, how the debtor is structured, who the equity interest holders are, and what the plan is going forward. I have a lot more in these slides that I'm going to go through, but there's some case law here that's going to basically highlight what you need to include in those documents. Disclosure statement, and then of course you have the Chapter 11 plan. Okay, it's not, Colette, this is not moving forward, but excuse me, let me just, there you go. The Chapter 11 plan. So that's usually filed with the disclosure statement. That is going to be the document that's going to put forth what the debtor is planning to do in the case, how it's going to classify certain claimants, and what the treatment is going to be as far as what they're going to get paid over time. Generally, for a plan to be confirmed, you need at least one class of impaired creditors. Impaired means they're not being paid in full, or their legal obligations are altered one way or the other. And then, of course, there's three other components of getting the plan confirmed by the court. It must be proposed in good faith. It must meet the best interest of creditors, which means that the creditors need to be paid more than they would get paid in a Chapter 7 liquidation scenario. And of course, the plan has to be feasible, which means it will be able to, the debtor will be able to consummate the plan. So with that, I'd like to jump ahead to this brand new chapter of bankruptcy. It's called the Subpart 5. Excuse me, I'm trying to get the screen to move forward. It's called the new Subchapter 5 Small Business Debtor Reorganization Act. It was enacted August 23rd, 2019. It just became effective in February 19, 2020. Now, this has nothing to do with coronavirus. I just want to make that clear. It just happened to be a coincidence that this came into effect at a very timely point in our history with the COVID-19. Debtors must elect this at the time of filing, and of course, the purpose of this is really to streamline a lot of those expenses and time issues that come up in a traditional Chapter 11 case. So the major differences in the Subchapter 5, and like I said, this is a brand new section, a Colette, next slide, please. Is that there's an appointment of a subchapter 5 trustee. Now, the subchapter 5 trustee they're a unique animal in bankruptcy court. My understanding is that they are to serve as a facilitator or a mediator between the debtor and the secured creditors. They will help the debtor get to a confirmation of their case, and that's basically, my understanding, that's their role at this point. Of course, I think their role is going to evolve over time. This act has just come into existence, so I'll be interested to see how that works out. There's no U.S. trustee fees. That means you don't have to file quarterly statements, or you don't have to pay any post-confirmation fees, which is usually a hindrance for a Chapter 11 debtor. You don't have to deal with a competing plan. Like I said before, the debtor in a traditional Chapter 11 case has only 120 days to file their plan. Otherwise, there could be competing plans filed. In a subchapter 5, that is not the case. Only the debtor has the right to file a Chapter 11 plan. There's no unsecured creditors committee generally in a subchapter 5, which is good. It's going to lessen the cost of the case. I should say that a committee can be appointed for cause. I think that's going to be very rare in these cases. There's no disclosure statement required. So like I said before, you need to file in the traditional case, you'd file a disclosure statement and a plan. In the subchapter 5, you only need to file a plan, but a lot of the information in the disclosure statement will be part of that plan. So you'll be filing one document, but it'll probably have a lot of the same information. Another huge benefit to the subchapter 5, in my opinion, is this concept called the absolute priority rule. What that basically means is if you were a small business owner and you are proposing a plan, in the traditional case, if you're only paying unsecured creditors, say 5% of what they're owed, you are not allowed to keep your business, because that's deemed as you retaining something of value before you paid your unsecured creditor something that's of equal value. That's called the absolute priority rule. So it basically requires a business owner to buy back their interest in their business in order to make the plan work. Typically, that needs to be paid by money or money's worth. It needs to be a reasonably equivalent value of whatever the value is in the business that they're retaining. It has to be upfront and substantial. What that means basically is it needs to be paid typically at confirmation. That's usually a Herculean problem for the small business debtors. They don't have $100,000 to put into the plan at confirmation, and that could be a reason why a lot of these cases for small businesses don't work. This new provision of subchapter 5 eliminates that absolute priority rule. It allows the debtor to keep its interest in the business as long as it pays disposable income over a 3 to 5 year period. So that's going to be something that should be very helpful to small businesses. Also, along those lines, administrative fees typically need to be paid at confirmation in a traditional Chapter 11 case. You don't need to do that in a subpart 5. You can pay those over time. So that's going to alleviate a lot of cash problems that a business may have going forward. And then finally, in most bankruptcy cases, you cannot modify a mortgage on your home. Okay, that's just something that you can't do in bankruptcy. In the subchapter 5, you will be allowed to modify a mortgage on your principal residence only if that loan you took out against your house was used to finance your business. So you still can't modify your principal residence on your home if you use that money to buy the house. But if you took a loan against your house to finance your business, you will be allowed to restructure that. Colette, next slide, please. So the subchapter 5 eligibility, you need to be a small business, obviously. You could be an individual or a business entity. The important thing is you have to be in business. It's not used for consumers. The aggregate is the amount. There's a debt limit on the subchapter 5 eligibility. This is important. It has to be. It can't be more than $2.725 million in non-contingent liquidated secured and unsecured debt. Now, after COVID, there was an act that was enacted by Congress, which I'll talk about at the end of this program. That's called the CARES Act. They have increased that amount from $2.7 million to $7.5 million for cases filed after March 27, 2020 for 1 year. This is going to really allow a lot of new businesses, to take advantage of this subchapter 5 because of that new increase in debt limit. Also, another thing just to note is that if you have a client that has mostly real estate property and they're generating most of their revenue from the real estate, they may not be able to use the subchapter 5. Subchapter 5s do not apply to what they call a single asset real estate company. Those are that chapter. There's a separate way of treating those companies under the bankruptcy code. They're a lot more restrictive, and the debtor needs to move very quickly on those type of cases. And of course, it generally can't be a general publicly traded company under the SEC, the Securities and Exchange Act of 1934. Colette, next slide, please. I'm going to spend very little bit of time on this. When a case is filed in subchapter 5, there's an initial status conference from that's scheduled 30 to 60 days after filing. That conference is with the court. The judge basically is supposed to hear from creditors, the debtors, and they basically set deadlines and determine whether or not you are in fact a subchapter 5 eligible debtor. The debtor can file a plan, but it can't file it more than 90 days after the petition date, so they are under a tight time frame to get their ducks in order. They can request an extension of time to do that. Confirmation, of course, is a lot easier in a subchapter 5. That's the whole point they enacted this. And basically, as long as it's fair and it pays more than a chapter 7 that the creditors would get in a chapter 7 liquidation, they will be able to confirm a plan. Colette, next slide, please. So what I just described between the traditional 11 and the subchapter 5, the new act is really for reorganizations. Folks should be aware that there are straightforward liquidations that you can accomplish in a bankruptcy case. It's called a chapter 7 bankruptcy liquidation. You will see most of these in the context of individuals with no assets. What happens in one of these cases, it starts the same way. You file a petition, schedules, but instead of the debtor basically running the whole show, a chapter 7 panel trustee is appointed in the case. They're randomly selected, and their job is to really marshal and liquidate the assets for the benefit of creditors and make liquidations. Their actions also include things like investigating the affairs of the debtor, examining the proofs of claim that are filed. They can oppose the discharge of the debtor if a warrant. They could file objections to exemptions that the debtor is claiming for their homestead, their clothes, whatever they're claiming exemptions for. And they could also commence what they call adversary proceedings, which are basically separate and parallel litigation in a bankruptcy case to recover property for the estate, which could be a preference or a fraudulent transfer. Colette, next slide, please. There's another chapter I just want to mention because this is an international audience. It's called Chapter 15. I'm going to spend very little bit of time on this. This is basically an act that was part of the amendment in 2005. It revises the old Section 304 of the Bankruptcy Code. And basically what this does is it allows the United States Bankruptcy Court to recognize a foreign bankruptcy proceeding. I listed the objectives under 11 U.S.C. 1501. You could read that for yourself, but basically the idea is to recognize that there's global commerce and that all the assets should be administered basically in one centralized forum. Colette, next slide, please. So in order to get recognition of a foreign insolvency proceeding, 3 requirements need to be met. The first one is such foreign proceeding for which recognition is sought is a foreign main proceeding or foreign non-main proceeding within the meaning of Section 1502. I'll explain that in a second. 2, the foreign representative applying for recognition is a person or body. And 3, the petition meets the requirements of 1515. 1515 just basically talks about the mechanics of what you need to file. There is a big case on this. In re Betcor case is often cited as to what a proceeding is in a foreign country. Basically, I'm not going to read every one of them, but basically it needs to be something analogous to our bankruptcy courts in the United States. It has to be a place where the assets and liabilities are being administered in a centralized forum, that all the creditors have an opportunity to participate, and it is authorized under the laws of that country. Colette, next slide, please. When I mentioned not main versus non-main, so a main proceeding is a proceeding where if you have, for example, a debtor that's in the UK and they have a headquarters there, if they get recognized in the United States, the automatic stay is automatically implemented, and no one could touch the assets in, let's say, New York City. If on the other hand it's a non-main proceeding, which means it's just a branch office in the UK or wherever foreign country it may be, then the automatic stay is not automatically put in, but it has to be specifically requested by the debtor. Colette, next slide, please. So what I described up to now are all, really the highlights of the federal bankruptcy system. I'd like to just discuss very briefly about state court insolvencies, particularly one that our office does a lot of. They're called assignment for the benefit of creditors proceedings. Basically, an ABC is a state court supervised insolvency. It's done through the state courts, not the federal court. So every state has a different statute on ABCs, and some states don't even have a statute on it. It's very similar to a Chapter 7 liquidation. It's commenced by a deed of assignment, which is a little different than a petition. It's typically it's treated like a land deed. The terms are a little different. A debtor is called an assignor, and a trustee, in this case, is called an assignee. The big notable differences between a state court insolvency and a federal bankruptcy court like an ABC is that the debtor can select its own fiduciary. It could select its own assignee, which is different than a Chapter 7 bankruptcy trustee, where a trustee is selected randomly by a panel. So the debtor has a little bit more flexibility in picking and choosing a fiduciary that's going to marshal and liquidate the assets for the benefit of creditors. Assets or sales are a little easier to achieve. While most ABC statutes do not provide a complete payment distribution scheme, a lot of practitioners on it, I know, you typically use the bankruptcy priority scheme for making distributions. ABCs were also a little less costly and more efficient because you don't have the reporting requirements that you would have in a typical federal bankruptcy case. The one thing you don't get in an ABC or any other state court insolvency is the automatic stay. So if you have an issue where there's active litigation, an ABC may not stop that automatically, but it can be requested by the court under certain circumstances. So that's just the ABCs are something to consider if you are liquidating a business in the United States. This is a nice state court alternative to a federal bankruptcy case. Next slide, please. So I want to just conclude with an act that was passed in March. It's called the Coronavirus Aid, Relief, and Economic Securities Act, the CARES Act. The whole idea of this was basically to curtail widespread layoffs amid the coronavirus and with the anticipated shutdowns of all the businesses that were taking place in the last 3 months. The bill is over $2 trillion. It's probably going to be more than that when they're done. The bill provided, part of it was a cash payment to individuals. If you made $75,000 or less, everyone got a $1,200 check. If a married couple made $150,000 a year, they got a $2,400 check. It also increased the unemployment insurance by an additional $600 a week until July 31st, 2020. Not sure if that's going to be extended. They also extended the tax filing deadline for everyone until July 15th, 2020. There was some talk yesterday that Mnuchin had hinted that may be extended again. I'm not sure if that's going to be extended. And student loan repayments were suspended through September 30, 2020. Once again, that may be extended as well. One of the big parts, now this bill had many other components that are not, I can't even begin to capture in a very short slide, but I could tell you that $100 billion went to hospitals, $10 billion went to airports, $1 billion went to Amtrak. There was a very big stimulus package that went through. But the one part I want to focus a little bit on is this Paycheck Protection Program. I know the people in the United States listening to this are familiar with it. It was $350 billion that was earmarked for small businesses. The program was set up like a loan, but it's a forgivable loan. The nice thing about it is no one has to pledge any collateral, and there's no guarantees when you obtain the money. It's targeted to businesses with 500 or less employees, as well as sole proprietors, independent contractors, and self-employed individuals. So it's really available to a lot of different types of businesses. The applicants must file a form 2483 and submit it to their bank. I'm going to show you what it's literally a one-page form, surprisingly simple for what you're getting. The loan amount is less than $10 million or 2.5 times an applicant's average monthly payroll. So it's a pretty robust financial package to businesses. Next slide, please. The catch is the loan proceeds must be used for certain things. They must be used to cover payroll costs. I mean, that's the whole point. One of the whole points of this thing is to cover your employees so you don't lay them off. The costs have to be related to the continuation of group health insurance plans. It must go to, of course, employee salaries, commissions, or similar compensation. You are allowed to use the money to pay your interest payments on mortgages, but you can't pay down your principal, so you only can use it for interest payments. You can use it for utilities, and you can use it for rent. So it's really used so business could continue operating while they were shut down. Like I said before, the PPP loan is forgiven if you basically use the money to pay 60% or more towards your payroll. They reduce that from 75%, so they relax that a little bit. The borrower can use the funds to cover costs until December 31st, 2020. That was extended from 8 weeks. And companies can rehire impacted employees, but they have until December 31st, 2020 to do this. So if they meet those requirements, they can, the loan will be forgiven. They don't have to pay it back. If they don't meet those requirements, it becomes a loan, but it's not the end of the world because the loan becomes a 5-year loan and with a monthly interest rate of 1%. So that's what's going on in the United States right now. We have a stimulus package. We have a brand new bankruptcy subchapter 5, which would be very interested to see how that works out. And that's where we are right now in the United States.
Rubén, sorry. Yeah, sorry, Rubén, your mic was on.
No problem. Thank you, Marc. I think it's an excellent presentation. It's a great support from the U.S. government to the small business. I think it's going to be a good, very good decision. Next one is the presentation of Raffaele. Please, Cecilia, tell us.
Let us introduce Mr. RIZZI. He's a member of the bar in Italy since 1992, in New York since 1994, and England and Wales since 2000. He has been practicing as the owner of Severino law firm, RDR law firm, as a owner since 2013 to date. The firm is specialized in advising on corporate governance, compliance, and disclosure matters under domestic and international regulations, acting as counsel to Severino law firm in Milan and as a sole partner of RDR law firm. He also collaborated as general counsel for Banca Monte dei Paschi di Siena from January 2007 until March 2013, managing the legal department as the chief legal advisor of the CEO and the board of directors, driving the the key merger and acquisitions and fixed income equity transactions, and top-level management of all corporate, international, and financial banking litigation. He also collaborated as General Counsel for Italy for Credit Suisse since November 1999 until December 2006. He was Italian counsel for all worldwide legal matters. Also, as a member of the Management Committee of Credit Suisse Legal Department and Country Representative. He collaborated in Baker McKenzie as partner in London and Rome from October 1993 until October 1999. He was also collaborated as visiting foreign lawyer for Quinn and Rakusin in Washington, D.C. from March 1993 until August 1993. For Andersen Consulting from November 1989 until December 1991 as an associate. His background in education, he has a postgraduate course in international banking and finance for Libera Università Internazionale degli Studi Sociali in Rome, Italy, from March until July 1995, at the George Washington University National Law Center, an LLM on international law in February 1993, and his thesis title was Joint Ventures under UIA Competition Law. He also participated in the Rotary International Foundation Scholar from January 1992 until February 1993. And he has the degree of Juris Doctor cum laude he obtained it in November 1989, also at the Libera Università Internazionale degli Studi Sociali in Rome. He has attained several awards and recognitions, and he has also issued several publications.
Thank you, Cecilia. Okay, Raffaele, go ahead, please.
Raffaele, sorry, it seems that there is a problem with your mic. We don't hear you. Can you try maybe without the earphones?
Raffaele, can you hear us? Can you hear us, Raffaele?
Can you hear me now?
Okay, yeah, go ahead.
You can. Thank you very much for the long introduction. I'm going to be, let's say, selective in what I'm going to describe today. I'm going to describe very briefly what Italy and the Italian government has implemented in order to face COVID in Italy. As you know, Italy has been one of the countries where COVID has had a very strong impact with a lot of problems and issues. COVID basically means for Italy a complete shutdown of the country for a couple of months. For a couple of months, the government has basically decided to shut down the country to avoid to have any problem with the COVID. Following the shutdown, basically, the government has introduced several potential measures to face the issues of the companies dealing with COVID. The main issue of the Italian companies has been liquidity. Given that companies have been basically shut down for such a long time, from a business point of view, liquidity has become a real issue for the country. And liquidity means also potential insolvency issues, given that if a company is short of cash, potentially it can face an insolvency issue with its own creditors. Therefore, the measures taken by the government have basically followed two different routes. The first one has been to provide as much liquidity as possible to the Italian government, sorry, to the Italian companies. And the second one has been to stop, if I can say, or stand still any kind of potential action that could force a company to go bankrupt. In other words, for a certain period of time, and more specifically up to the end of this month of June, a court cannot be declared insolvent in Italy. It's a kind of standstill situation, given that the companies in Italy are currently facing a real issue with liquidity. The government has decided that in order to allow the companies to face this issue properly without having any problem of insolvency, the only way was to stop the possibility to claim insolvency of a company. This is a quite unique measure taken by the government. I would say the first time I have heard in my life to stop any kind of proceeding in relation to insolvency. And this has been only one of the measures taken by the government. Basically, the government, in relation to any type of insolvency procedures, has given the companies the possibility to deal with it properly. And the only way to deal with it has been to give more time to the companies to find the proper balance after the COVID period. That has been a major effort by the government that has been matched by other very important measures. First of all, from a tax standpoint, the government has basically stopped any type of payment of tax payment in Italy. Again, to avoid to force the companies to lose further liquidity, and stopping the payments, the government has allowed the companies themselves to get more cash in their hands to use for their own business. The third major approach taken by the government, they also stopped the possibility to fire employees. In other words, there has been a standstill on the possibility to fire people. That has been the third measure, together with no possibility to go bankrupt, no possibility to postpone the payment of taxes. The government has basically forced the companies not to fire people. At the same time, even if you cannot fire people, as Italy allows the companies to put the employees under the umbrella of the government for a certain period of time in the event that they are not able, the companies, to give proper work to the employees themselves. Then to stop payments, to stop bankruptcy, to stop firing is not the only measure. The other big measure taken by the government has been basically to give cash to the companies. And this has been done through two different ways. That is through the Credit Export Agency, Italian Credit Export Agency. The name of the agency in Italy is SUBCHAPTER, that has been used by the government to guarantee loans granted to big medium-sized companies. In other words, the government has used two different routes to finance and to guarantee loans granted to the companies. On one side, the first route is the granting of a guarantee by the Credit Export Agency, SUBCHAPTER, for medium, big-sized companies. And on the other side has been the creation of a special fund for small companies. The difference between the two approaches is bureaucracy, if I can say so in a nutshell. For big companies, the procedure is a little bit more complex, also because we're speaking about a relevant amount of cash. Maybe you have heard that even Fiat, the Italian car maker, or partial Italian, I would say, currently, has been used this kind of guarantee. Of course, in order to have this kind of guarantee by the credit export agency, there is a kind of procedure to be followed and some steps, procedural steps to be taken. On a different approach, the fund created for small companies that has a cap to 2.5 million euros for each loan is a little bit more straightforward. The procedures are extremely simple and in a way practical in order to allow less sophisticated companies, the small companies, to have access to the fund without any bureaucratic, if I can say so, procedure. Then two different approaches, more complex for big companies, big amounts, simpler for smaller companies, smaller amounts. That has been, I will say, quite a success so far for the number of companies that have applied to this type of financing and guarantees. The third step taken by the government has been to protect Italian companies. Of course, in a period like this one, whereby the value of the companies on the stock exchange has been declining substantially, the bigger risk has been, of course, to have the possibility for non-Italian investors to buy companies at a very cheap level. That is, of course, part of the game, I would say, in a democracy, in an open economy. But at the same time, the government, taking advantage of the specific regulation of the European communities, has issued a special protection for companies that operate in some critical areas of the state. And the areas are telecommunications, of course, government-related companies, cybersecurity, all the companies that have, generally speaking, access to sensitive information of Italian citizens, and supply of essential services in Italy. All of these has been basically issued by the government with a specific piece of legislation, and this can be, in a way, in a nutshell, called the exercise of a golden power by the Italian government. This is the third area where the government has been basically approaching the state and helping the country. I would say that the Italian citizens have much appreciated this effort, have probably not realized much that the government has now a large power, golden power, to stop basically the purchase of Italian companies by non-Italian companies. But this is something that is going probably to be implemented by the government in the next few weeks, months, in relation to potential purchases in Italy. That is going to be quite interesting how the government is going to apply it, also in view of the relevant European regulations on this matter. Last but not least, the Italian government is financing the health system. There's been a major financing approach towards the health system in Italy. In the health system, and that is public in Italy, mainly public, whereby everybody can have access for free to medical cure and protection in Italy, has been extremely strengthened. Right now, the government is spending quite a lot of substantial amount of cash to make available to the Italian citizens more hospitals, more doctors, and more assistance. Because what we have realized is that COVID could be only potentially the first one of potential diseases coming from other countries. And the country needs to be strong enough to face promptly these kind of issues in order to allow our economic system to be able to work and keep producing without any issue similar to the ones that we've been facing for COVID. Thank you very much.
Thank you, Raffaele. It's a great presentation. Please, Cecilia.
We're going to introduce Mr. Rubén Acosta, a little bit of his background. He has been practicing as an attorney since 1999 when he obtained his law degree from the Universidad de Guadalajara. He also obtained a master's degree in trade law from Universidad Panamericana. He also has a specialization in senior management program, also from the Universidad Panamericana, a higher education program, and several diplomas in corporate law, business administration, international business, American business in San Diego, California. Also in Harvard Business School, the leading global growth through innovation program. He has been university teacher for several years, up to date. He is a co-author of the book Civil Procedural Law, and he also is a speaker at Instituto Panamericano de Alta Dirección, a higher education program. He is a litigation attorney at the Jalisco Forum. He is a member of the Mexican Bar Association. He is the president of the Bankruptcy Law Commission of the UIA. He's partner and counselor of several companies in the transportation, health, real estate, energy, and commercial fields. And he's also a member of Greenpeace International.
Thank you, Cecilia. The first slides, please, Colette. Next one. Okay, this is the situation in Mexico. Mexico have 130 million people, and is the next one is the 11th globally economy ranked. Have a GDP around 1,221 billions in American dollars. Maybe these years the GDP will fall 7.5% in this year. Why? Maybe because the coronavirus, because the China and United States dispute, the price of the oil are, and also the elections in United States and Mexico. Maybe that's the problem of the situation of the economy. Next one, please. A lot of companies in Mexico have problems and financial problems because the pandemic, it begins in March. We have a bankruptcy law since the year of 2000, and many companies are using this law to solve their problems. The law in Mexico is have two stages: reconciliation and bankruptcy. Since this law until November 2019, there is a 772 bankruptcy proceedings. As you know, are a very less proceedings in a big country, big economy for Mexico. What is the situation right now? Since May, all the federal courts are closed because the pandemic. And next one, please. Next one. Next one. Okay. Because the federal courts are closing and they only receiving urgent cases, I think, and that's what I told Marc, that's why a lot of Mexican companies go to United States, specifically to New York, to file the bankruptcy proceedings. I don't know, it's because it's more quickly and easy in United States, or because the courts in Mexico are not working totally. Next one, please. The federal courts only are receiving urgent cases. Only urgent cases are right now in the Mexican courts. All the rest of the cases are stopped. But in the bankruptcy system, it's considered urgent only the provisional remedies in the bankruptcy proceedings. Next one. Next one. What the court have to know in this situation is to keep the company, to keep the assets of the company, and to keep the operation of the company is the only things that are doing the federal courts right now in the bankruptcy systems. There is a new project, a new initiative is making by my college, the Barra Mexicana Colegio de Abogados, make a initiative, and it present to the Senate of the Republic. The Senator Claudia Edith Anaya Mota presented the initiative to the legislature. What about this legislator is the situation is to have a new chapter in the law. The chapter, next one please, is about the regulate bankruptcy proceedings in emergency situation. As you know, in Mexico, we have not only the coronavirus problem, we have a lot of earthquakes. Yesterday, we have an earthquake in Mexico City and Oaxaca state, and several hurricanes in Mexico. That's why this is the proposal, the new chapter to regulate the situation and emergency situations. We have a big country and different kind of problems. It could be national or it could be regional. Next one, please. This initiative, what it says is to make more quickly, less requirements, and maybe in a fast track situation to resolve all the bankruptcy in this emergency situation. And next one, please. We are very happy to have this initiative because we need to regulate what's going on with the bankruptcy proceedings in these kind of situations. Because right now, the companies in Mexico have a real few problems.
Sono l'avvocato Rizzi, cercavo il notaio Atlante, Nicola. Sono il...
And everybody here are very interested in this new project. There is a lot of opinions about this one, the bankers, the entrepreneurs, the workers, but I think it's a good time to analyze this situation. This is the situation right now in Mexico, and if you have the audience have questions, please make it by writing to each one of the speakers. I don't know if Marc or Raffaele want to say something at the end of this webinar.
Well, I'll just say that unlike what I heard in Italy and in Mexico, the bankruptcy courts, at least in New Jersey, are operating. Cases are being filed. The only difference is that hearings are done telephonically. It's interesting on 341 hearings, that initial meeting of creditors that I described earlier, that's being done telephonically, which is going to be interesting because typically that's the first interview with the debtor by the trustee, and they have to be comfortable that the person that's testifying is actually the debtor. They're doing that by telephone as of a month ago. I don't know if they moved that to Zoom, but for the most part, the bankruptcy courts are moving fairly regularly. I mean, there's like I said, I see filings every day. I'm involved in a group of cases right now. Papers are being filed, plans are being filed, and in the state court as well. I think the only big difference right now is jury trials. Jury trials, which are not in bankruptcy court but in state court, are not moving forward for obvious reasons. But it's business as unusual as the judges say here in New Jersey.
Okay. Raffaele, do you have something to say? Okay. Well, thank you very much to all the speakers. Thank you very much to all the people and join us. And this is the end. Thank you to the International Association of Lawyers. Thank you very much.
Thank you very much.
Thank you, everybody.
Thank you.